detail and includes specific statements of specified witnesses, locator information of witnesses, forensic details, and reference to Mr. Merritt's circumstances other than his criminal history. This court finds that facts presented to this court that were not facts made available to the initial appearance court justify a renewed look at the terms of Mr. Merritt's pretrial release. The court now will address how today's proceeding will be conducted. To release the material filed under seal would be to invite the prospects of civilian and media attempts to double-check, research, and analyze the facts and theories presented, the likelihood of attempts to contact potential witnesses. Rule 15.4d presumes that materials uncovered and disclosed by the parties pending trial are not public record. This court reads the rule to intend that the pretrial preparation should be done by the trial attorneys and their designees and not be under public scrutiny or comment. Also, some of the facts presented in the proffers will require pretrial determination of admissibility. To disclose them now may allow potential jurors to be influenced by information that they would not otherwise need or should have to make their judgments of the trial facts. Some of the facts presented in the proffers have specific names and locator information. Any terms of release always includes that the defendant not attempt to contact witness. The term is designed to reduce the intimidation of witnesses or make them reluctant to cooperate. Such intimidation or reluctance may also spring by contacts of these folks by civilians or media representatives. For these reasons, it is therefore ordered that the pleadings of counsel filed for today's proceedings remain filed under seal to enhance the chance that Mr. Merritt and the victims receive a fair trial and to reduce the chance of harassment of witnesses. This court will attempt to conduct the balance of today's hearing in such a way as to reduce the prospect of victims and witnesses' names and locator information being released on the public record. With respect to today's proceeding, the mere fact that a defendant has been charged with the crime is not sufficient to overcome the presumption of OR release. The rule allows for the presentation of facts and the court to modify release conditions without regard to rules of evidence. This court reads that rule to show that this is not intended to be a trial, mini-trial, or dress rehearsal for a trial. For that reason, the court will consider all of the pleadings that were submitted by both parties in making today's decision with respect to release conditions. The purpose of a bond and release should include assurances that the defendant appear for court, protect against intimidation of witnesses, and protect the safety of the victim, persons of the community. When the defendant is entitled to release, as Mr. Merritt is in this case, this court is obliged to consider the views of the victim, the nature and circumstances of the offense, the weight of the evidence, the accused's family and employment ties to the community, any drug test results, the accused's length of residency in the community, the accused's criminal history, and the accused's history of making prior court appearances. Both of the parties' proffers have focused mainly on the weight of the evidence. Because this is not a proof-evident presumption break hearing, the court must consider the other factors set forth in 3967. So for that reason, Mr. Leiter, a couple of questions.
Yes, Your Honor.
Did you have a chance to review the defense pleadings?
I did, Your Honor.
Would you concede that they represent a defense that is not likely to be precluded and therefore be considered by the trial jury?
I would concede that.
Would you also concede that its presentation is only effective if Mr. Merritt is sitting in the courtroom at the time it's being presented?
I would concede that, Your Honor.
What, if any, terms of release do you deem appropriate to secure the attendance of Mr. Merritt, prevent any contact or harassment of the victims, and ensure the safety of the community?
After the state's review of the pleadings, Judge, the state does not believe modification is appropriate. If the court does deem modification appropriate, and I would just reference the pre-sentence report, the maximum conditions of release is what the state would be requesting.
Mr. Lamb, the state, I didn't ask this question. Mr. Leiter, in light of the defense pleadings, does the state intend to proceed with the charges?
Yes, Your Honor.
Mr. Lamb, would you concede that the state's pleadings represent at least a probable cause that Mr. Merritt may have posed a danger to specific persons and therefore a danger to the community?
We would concede that there is probable cause, but no greater evidence than as is required under that standard.
What release conditions would you recommend to ensure the presence of Mr. Merritt for his trial, that he not contact any victims, and that he pose no risk to the community?
Judge, number one, Mr. Merritt has no idea who the victims are. The court knows our position, and it is very clear from that position that he has an alibi for each and every one of the incidents alleged. So with respect to victim contact, that's a non-issue. That having been said, as we indicated in our pleadings, we will agree to a release to pretrial services with electronic monitoring. Now, of course, with an ankle bracelet, there is GPS tracking ankle bracelet. So the court, and frankly the state, will know where he is at any and all times. With respect to the issue of a curfew, I would respectfully suggest an open curfew. The court knows that he works as a landscaper. His employment remains available. Frankly, we don't believe he's a flight risk. We know that he will be here, but frankly, we offer this almost as an olive branch to the state and invite them to track his whereabouts, to see that he is not doing anything nefarious. And of course, with respect to any alleged danger to the community, certainly we would agree to a condition that he possess no weapons, explosives, or any other destructive devices, but in fact, that's a standard release condition. If the court would like a third-party custodian, one of the references in the pretrial services report, reference number 2, is present in the courtroom. That is an individual with whom Mr. Merritt would reside with his fiancée. So that individual is someone who will have daily oversight and contact with him. That person has no criminal history, gainfully employed, frankly, a very stable family environment. And if the court wants to take that up further, we would certainly welcome that. But I will make the offer of proof that that person is sitting here and is willing to be a third-party custodian.
2 logistic questions. If released, does Mr. Merritt know what work hours he would be, what work days there would be?
Typically, he works on a Monday through Friday schedule. Now that the winter is upon us, I believe he'd probably be starting a little bit later as opposed to...
You can check with him if you want.
If I may, please. Generally speaking, a 7 to 3 or 7 to 4 schedule. So, Your Honor, to accommodate travel because it may be around the valley, if we give him about an hour or 90 minutes on each end, and of course, because he'll be GPS, we'll know where he is at all times.
With respect to where he would be residing, are there any guns in that residence?
There are not.
Mr. Leiter, having heard a specific proposal by the defense, does the state have any position?
The state's position remains that modification is inappropriate at this time, Judge.
Thank you. Mr. Leiter, do you know if the victims have a position on release?
The victims, each of the victims has been contacted, Judge. It is my understanding that they oppose any modification.
Thank you. Having considered the proffers of counsel filed under seal, the comments today, and the two pretrial release investigations that reflect, that cover the issues of negative drug test results and negative criminal history, the court does find that release conditions should be modified. I do want to create incentive for Mr. Merritt to stay and come back. Mr. Merritt, not the least of which is that your defense is best presented with you sitting in the courtroom. Do you understand that, sir?
Yes, sir.
And that while we don't have a trial set today, we will, and that trial could proceed without you. Do you understand that, sir?
Yes, sir.
The court will affirm the prior release conditions that you not return to the scene, that you not initiate contact with the victims, that you not have any physical contact with any of the alleged victims, that you not yourself initiate contact with any of the witnesses.
Yes, sir.
That you not initiate contact with any of the police officers or state witnesses.
Yes, sir.
That you not possess any weapons, and the court would abide the broad definition that we have of possession. That's constructive possession and joint possession of a weapon. Do you understand that?
Yes, sir.
That you not possess any drugs without a valid prescription.
Yes, sir.
That you not drive a motor vehicle without a valid driver's license.
Yes, sir.
That you continue to provide the court with a location, which you may file with the clerk, that you maintain contact with counsel.
Yes, sir.
But it's not a legal thing, but to put some skin in the game, I will require that you post a $150,000 bond, so that you can consider other folks before you decide to leave.
That secured appearance, Your Honor?
Yes.
Your Honor, did the court intend to hear any further arguments of counsel concerning that? Because there is additional evidence that we had intended to pursue in the form of an evidentiary hearing that goes beyond the pleadings.
Mr. Lano, I'm sorry. I thought we had covered everything. I didn't intend to cut you off. If there's anything else that you want to proffer, now is the time.
Beyond what's in the pleadings?
Yes.
Judge, you know that we intended to call several witnesses, two of whom are from Florida today. And really, it begins with the 1104 phone call from what I'll call the Verizon phone, and I think the court understands what that means. And I think what I should say at the outset is that the state's issue, at least as I perceive it, is whose phone is it? And the court heard Exhibit 3 to the reply, which is now, I'm offering Exhibit 1 for this hearing.
All of the exhibits mentioned in the pleadings are going to be incorporated with in today's hearing as exhibits.
Very good. Well, what we've actually done is go forward with these two individuals in Florida. We have obtained the aunt's work records. We mentioned that she was doing online testing for her employer.
Since I have sort of readjusted the situation, you're again talking about the weight of the evidence, which is one of the factors. If there are any modifications to any of the specific terms of release I've just set forth, I want you to address those.
Judge, specifically, it's the bond that we're going towards. When we talk about financial resources, Mr. Merritt has no ability whatsoever to make that bond. And I appreciate the court making the gross deviation that it did based on the newly presented information. But the court, and while we thank the court for its ruling, $150,000 to him is the same as $1 million. There's no property that he or his family has to post. When we talk about skin in the game, he has nowhere to go. He has 2 children. He has a fiance. What we're simply telling the court is that there's absolutely no potential of a flight risk. You have already addressed he has no criminal history. He has no failures to appear. But I believe that based on what we have before us, and frankly the financial condition is an important thing to discuss, because with a defendant, and I've had this with other clients who have means and resources, the bond is on a sliding scale and is much higher. Whereas we have someone here who doesn't have the resources, but under 3967 has that presumption of being released on his own recognizance. So if the court is inclined to do 150, I would respectfully ask the court to take out the collateral from that. That if he were able, and I'm not saying $15,000 cash is something that's going to happen overnight or next week or even by Christmas, but at least that there's a realistic prospect, because for this man, a 22-year-old landscaper with 2 small children, $15,000 is like $1 million to him. And that's a lot of skin in the game. This is someone who, as the court knows, had, shall we say, several dozen times in his interview, in addition to at the initial appearance court. He didn't do it. He has every reason to appear, and as the court pointed out, he can't have a defense at trial. He cannot have a defense at trial unless he's sitting here. And to the extent that the court or the state is concerned that he won't appear at a trial, even though we're not really ready, I would almost invite Your Honor to set a trial date so then trial could proceed in his absence. That's additional skin in the game. He runs the risk of being tried in absentia if there actually is a trial date, even within the last day. This man has every incentive to appear. He's nodding his head.
I'll be there. Treating that as a motion to modify my verbal order, Mr. Leiter, what's your position?
Your Honor, the state, in this case, the court has considered, I would wager, probably more information, more pleadings than you've ever had to consider for the purpose of a motion to modify. The information supplied by Mr. Lamb is intended to play on the heartstrings. And frankly, his ability to post the $150,000, that's not part of the consideration. Your Honor has considered all of the information provided, and as such has lowered the bond. The state understands and respects that, and we ask that you maintain the ruling that you've already made.
Motion, Mr. Lamb, you get the last word.
Judge, I just want to reflect back on the state's, I believe it was the response, not the supplemental response. And when they talk about the alibi, they say that we have failed to exclude him from the scene. But respectfully, it is the state, it is the government that has the burden of proof. They have failed to include him. There is cell site data, cell phone tower analysis done by the FBI that puts him in Glendale at his home at the time of these calls. And I know the courts already consider that. I know the courts consider that judiciously. But at the same time, this is a man who's presumed innocent. And as we sit here, we have yet to see any evidence that puts Leslie Merritt Jr. along the I-10 freeway at the time of any of these shootings. So I'm going to re-urge my motion based on that.
Again, your points are dealing with the weight of the case, which is just one of the factors. Not to invite relitigation, but the information that you're providing now and ability to pay, if you will, is not something that was focused. So the court will order the release of Mr. Merritt right now with a $150,000 bond if there's a requirement. If there's a change of circumstances, I can hear a change of circumstances. We are all here now. Is there anything else that we can do today that we haven't, Mr. Leiter?
Your Honor, there are some discovery requests by the defense. Specifically, I believe the state has complied with the 3 filed motions in terms of specific discovery requests. If there's any item missing, and there was a large amount of discovery that was supplied for the defense last Friday, I would just ask Mr. Lamb to notify us, given the voluminous discovery in this case.
Do you need any orders from me to get the stuff that you think you need?
In terms of what has been requested, and let me be clear, Mr. Lamb made 3 formal filings with the court. In terms of those requests, I believe we've complied with those requests. Mr. Lamb I want to say last Wednesday, November 11th, sent me a letter that was asking for additional discovery. State's position is pursuant to 15.1c. We have 30 days from that point. I'm going through those specific requests. We're going to have a responsive filing to those requests. A lot of those materials, I believe, were disclosed last Friday. But in terms of this being the IPTC, I think that's what we called this, among other things. I believe we are well on pace, ahead of pace, frankly, to make sure the defense has all of the information in this case. One of the critical pieces of information that was requested by Mr. Lamb, including any photos or lab reports associated with the forensic testing, some of that material was disclosed to him to the defense last Friday, and the remainder of those materials will be disclosed by the end of next week.
Mr. Lamb, anything that you want to report or anything that you need today?
Judge, I filed several motions for supplemental discovery, and the court has seen them. They discuss other freeway shooting incidents that we've uncovered in our investigation. The state never responded to those, so I took the unusual step of filing a motion for summary disposition last week. I'll certainly give the state an opportunity, but that's very much on the front burner right now. With respect to the ballistic issues, yes, we did get a dump truck of discovery at about 3 o'clock on Friday, and there were photos contained. But we still just have the lab conclusions. We don't have the analysis for our expert to sit down and look at. Now, I will say that the discovery is voluminous. I am not casting any bad faith or aspersions on Mr. Leiter or Ms. Lasico in any way. But because for the time being it looks like our client's going to be sitting in the lower Buckeye jail, we want this discovery to move forward, and we need to press on. With respect to the additional items that we requested, essentially these were materials that were referenced within the disclosure, and we treated it as a Rule 15.7b precursor letter. Much of it was covered late Friday afternoon, but a lot of things are still outstanding. I think that when we get some additional discovery, including the supplemental items that we've requested and the state has not objected to, we'll be in a much better situation to set a trial date, and I'm asking that we do that before Christmas. I think it's feasible that if we get these materials, we can get this case in gear and try it accordingly.
Other than that, a trial setting, a next court date hearing, you need anything from me today?
Just we have to deal with those supplemental disclosure requests.
Mr. Farragut.
Not to cut Mr. Lamb off, Your Honor, but because the information that we are receiving from the state and that we, the defense, are also investigating is fluid, and we continue to uncover information that excludes Mr. Merritt from these shooting allegations, will the court permit us to revisit the release conditions if we provide the court additional information as the discovery comes in, both from the state and from our investigators, that may continue to show that Mr. Merritt is not the shooter that the state has alleged?
Well, again, only because that addresses the weight issue. If you have, this is what I hear, the focus of your objection now is on the amount of the bond. Correct. So anything that deals with that would be probably a better way of going than focusing on the weight of the evidence, short of them dismissing the case. It's all going to be packaged into that one I-67 category.
Understood. But again, I guess my basic question is, if we are able to provide the court additional information, can we come back to the court?
You can come back anytime, but like I said, I'll be more focused on other categories of 3967.
Correct. Thank you.
With respect to the discovery, I will again remind the parties that 15.4 says the discovery is generally done between the two counsel. I'll only get involved if there's a need for it to be involved. In conjunction with my prior order, I would ask that all of the discovery motions, because they, by necessity, are very specific, that they be filed under seal. Or, if not, they not necessarily need to be filed with me. They need correspondence between counsel is sufficient, as long as there's an agreement. If there's a dispute, then you can get filed, but then that should be filed under seal. Off the record, just for scheduling, Mr. White, did you want a Friday setting for your trial schedule, or does it matter if we're just going to be on the 8:30 calendar?
From the state's perspective, on the 8:30 calendar would be fine. Unfortunately, I think all of my Decembers are spoken, my Friday Decembers are spoken for as well. I'm fine with an 8:30 setting.
We're here apparently until December 18th, so I'll set any date before that. You guys want to come up with a date?
You can do the 18th.
They want it sooner than that.
Is the court available on December 16th at 8:30?
Yes, the court will set a case management conference for December 16th at 8:30. The parties need something in the intervening time. They can ask any orders that you need to get materials that require a court order. If you submit them, I will sign them.
Does the court want a joint case management plan
That would be great.
publicly filed or not so much?
But I'll let you guys talk about it. Sometimes it has less information than others. Again, the goal is that we try this case in the courtroom with jurors that know only admissible evidence. So with that, as the guideline, I'll let you guys talk about that.
Yes, sir.
Anything else for now, Mr. Leiter?
Nothing, sir.
Mr. Lamb?
No, Your Honor.
Blasico?
No, thank you.
Mr. Farragut?
No, Your Honor, thank you.
Thank you. You're adjourned. Paperwork to fill out.
Your Honor, can the release order also be sealed in that it would contain his prospective address?
Yes, thank you.
I'm a good couple.
Mr. Lamb, the jail needs to have a copy. They will need his address.